Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, damages in depth, measuring and limiting legal relief. Let's begin. Damages are the ordinary legal remedy. On a California essay, the strongest answers do not merely say the plaintiff gets money. They identify the interest being protected, select the correct measure, then police the award with the limits of foreseeability, certainty, causation, mitigation, and avoidance of double recovery. Remedies is often tested as a second layer on top of contracts, torts, property, or fiduciary misconduct, so your analysis must connect the remedy to the underlying right. In California contract cases, Civil Code Section 3300 states the basic measure, the amount that will compensate the injured party for all detriment proximately caused by the breach, or likely to result from it, in the ordinary course of things. Civil Code Section 3358 prevents recovery greater than the amount that could have been gained by full performance, except where punitive or statutory rules apply. Civil Code Section 3359 denies damages that are not clearly ascertainable in nature and origin, while Section 3360 allows nominal damages when breach is shown but substantial loss is not. A damages award must be legally caused, measured by a recognized remedial interest, proven with reasonable certainty, foreseeable when required, and reduced by losses the plaintiff reasonably could have avoided. The plaintiff may plead alternative measures, but may not obtain a double recovery for the same injury. For breach of contract, damages usually include general damages that naturally flow from breach, plus special or consequential damages if they were foreseeable at the time of contracting. The classic foreseeability rule asks whether the loss arose naturally from the breach or was within the party's contemplation because of special circumstances known to the breaching party. California expresses the same idea through proximate cause and ordinary course language in Civil Code Section 3300. Identify the underlying claim. Contract, tort, restitution, fiduciary breach, and property claims use different measures. Identify the protected interest. Expectation protects the promised exchange. Reliance protects expenditures induced by the defendant. Restitution protects against unjust enrichment. Tort compensation protects bodily, emotional, dignitary, or property interests recognized by law.
Prove causation.
The plaintiff must show the defendant's wrong was a substantial factor or proximate cause of the loss. Contract damages must be caused by the breach, not by market forces or the plaintiff's unrelated business problems. Select the measure. For expectation, compare the value promised with the value received, then add other recoverable losses and subtract costs avoided. For reliance, total reasonable expenditures made in preparation or performance, subject to limits. For restitution, measure the benefit conferred on the defendant, often by value of services, property, money received, or increase in defendant's assets. Apply limitations. Foreseeability, certainty, mitigation, avoidable consequences, and no double recovery are not afterthoughts. They are frequently where the exam points are. Expectation is the default contract remedy. The formula is loss in value plus other loss, minus cost avoided and loss avoided. If a builder breaches after partial performance, the owner may seek cost of completion unless that would create economic waste, in which case diminution in value may be used. If a buyer breaches a sale contract, the seller may seek contract market difference, lost profits if resale does not make the seller whole, and incidental damages. If a seller breaches, the buyer may seek cover damages or market difference plus incidental and consequential damages. Reliance is useful when expectation is too uncertain, especially with new businesses, preliminary agreements, losing contracts, or promissory estoppel. The plaintiff asks to recover expenditures reasonably made in reliance on the promise. The defendant may reduce reliance by proving the plaintiff would have lost money even if the contract had been performed. Reliance cannot be used to put the plaintiff in a better position than performance would have produced. Note: reliance is not a consolation prize for weak causation. The plaintiff still must show expenditures were induced by the promise and were reasonable. Restitution focuses on defendant's gain rather than plaintiff's loss. It may be available when a contract is unenforceable, rescinded, avoided, materially breached by the defendant, or when the plaintiff elects restitution instead of expectation. A breaching plaintiff may sometimes recover the value of benefits conferred in excess of damages caused by the breach, but a willful breacher receives less sympathy and may be limited by contract terms or policy. Incidental damages are costs reasonably incurred in dealing with a breach, such as inspection, transportation, care of goods, cover, resale expenses, or reasonable efforts to minimize loss. Consequential damages are secondary losses caused by the breach, such as lost business profits, shutdown losses, injury to property, or liability to third parties. Consequential damages require careful foreseeability and certainty analysis. General damages versus special damages. General damages arise in the ordinary course. Special damages depend on particular circumstances known to the defendant. Expectation versus reliance. Expectation gives the benefit of the bargain. Reliance reimburses change of position. Do not award both for the same item. Reliance versus restitution. Reliance asks what the plaintiff spent. Restitution asks what the defendant received. Certainty versus mathematical precision. The fact of damage must be reasonably certain, but the amount may be estimated if the evidence provides a rational basis. Mitigation versus contributory fault. Mitigation concerns avoidable losses after the wrong. Comparative fault concerns responsibility for causing the initial injury. The most common trap is awarding every number in the fact pattern. Sort damages into categories and reject duplicates. If the plaintiff recovers the contract price as expectation, she usually cannot also recover all expenses that were supposed to be paid from that price unless they are separate incidental or consequential items. A second trap is ignoring costs saved. If a contractor expected to spend $80,000 to complete a job but was excused from performance by the owner's breach, expectation profit is not the full contract price. Subtract saved labor, materials, overhead tied to the job, and other avoided losses. A third trap is treating mitigation as a duty owed to the defendant. It is better described as the avoidable consequences rule. The plaintiff cannot recover losses she reasonably could have avoided without undue risk, burden, humiliation, or expense. The defendant bears the burden to prove avoidable loss. On a California essay, write damages in layers. Start with the best measure, then alternatives, then limitations. For example, P will seek expectation damages under Civil Code Section 3300, value promised minus value received, plus foreseeable consequential and incidental losses, minus costs avoided. The lost profits are consequential and recoverable only if foreseeable and reasonably certain. D will argue mitigation because P rejected a comparable substitute transaction. Then apply facts relentlessly. If the breaching party knew the plaintiff needed timely delivery for a public opening, lost opening week profits are more foreseeable. If the plaintiff has no sales history and only a hopeful projection, profits may be too uncertain, but reliance expenditures and restitution may remain available. If the plaintiff could have covered promptly at a reasonable price, later market spikes may be unrecoverable. End with a clean conclusion that states the likely recoverable categories and exclusions. The best bar answers sound like a judge building an award, not a student reciting labels. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.